Welcome to the Nimbus Consulting Group's tutorial on the State Mandated Cost Program, Local Government Employee Relations, also known as PERB. This mandate creates an agency shop arrangement and expanded the jurisdiction of the Public Employment Relations Board to include resolving disputes and enforcing the statutory duties and rights of those public employers and employees subject to the Myers-Milius-Brown Act. Whenever you deal with state-mandated cost claims, you deal with the fiscal year. This claim currently has two separate deadlines. For cost incurred during fiscal year 2008-09, these claims are due on February 16, 2010. The initial filing for cost incurred during fiscal year 2001-02 through 2007-08, these claims are currently in late status and are due no later than December 1, 2010. For those claims in late status, each of the fiscal years will incur a 10% late penalty. Costs can come from several different departments, not just one. Costs can come from human resource, city attorney's office, city manager, maybe it's a county council, or perhaps you hired outside counsel or an outside consultant to help you. This program contains several one-time activities that are reimbursable. This includes the time spent to establish procedures and documentation for taking deductions from employees' wages, the payment of dues or service fees, including transmittal of such payments and handling proof of in lieu fee payments made to charitable organizations as required by the agency shop arrangement. It also includes the time spent to provide training to employees charged with the responsibility for responding to PERB administrative actions. This may include your attorneys, supervisors, or management personnel. Remember, you can claim one time per employee. Also, the time spent to establish procedures and systems for handling PERB matters. This can include calendaring, docketing, and file management systems. This program has several ongoing activities that are reimbursable. The time spent to deduct employee wages, the amount of dues or service fees required by the agency shop arrangement that was established, and the time spent to transmit such fees to the employee organization is reimbursable. Also on a monthly basis, the time spent to receive employee proof of in lieu payments made to charitable organizations pursuant to an agency shop arrangement that was established by signed petition or election is also reimbursable. This activity may be where your agency is experiencing the most cost. When a person or entity other than the public agency files with PERB an unfair practice charge, a unit determination, representation by an employee organization, recognition of an employee organization, or an election request, the public agency employer is ordered by PERB to join in the matter. If that happens, the following activities are fully reimbursable through state mandated cost. The first is filing documents or request for an extension of time to file documents with PERB. Proof of service, including postage and service costs, are also reimbursable. The preparation for and participation in informal conferences required by PERB board agents and PERB administrative law judges for the purpose to clarify issues and explore the possibility of a voluntary settlement, including the preparation of briefs, documentation and evidence, exhibits, witnesses, and expert witnesses are reimbursable. Responding to subpoenas and investigative subpoenas, including the time to obtain information or documentation requested in the subpoena, this would include your copy and service charges as well, is reimbursable. The time spent to conduct depositions, including the service of subpoenas, the deposition reporter and transcription fees, expert witness fees, and the preparation of these activities, including any government employee or attorney cost, is reimbursable. The preparation for and participation in any hearing required by any PERB board agent, PERB administrative law judge, the 5-member PERB, or the general counsel is reimbursable. This can include the preparation of answer to complaint or answer to amend, witness evidence, exhibits, expert witness statements, stipulated facts, informational briefs, oral arguments, response to exceptions, response to administrative appeal, or compliance matter. Also, the preparation, research, and filing of motions, including correction of transcript and responding to written motions in the course of a hearing, are reimbursable. There are several non-reimbursable activities associated with this program. Certain governmental codes do not apply to peace officers as defined in Penal Code 830.1. Also, as of May 11, 2006, responses to petitions for board review pursuant to former sections of California Code of Regulations Title 8 are not reimbursable. If the public agency initiates any of the items listed on this slide, then that cost incurred is not reimbursable. These actions include the public agency filing an unfair practice charge, an appeal of ruling on a motion, amending a complaint, appeal of an administrative decision, statement of exceptions to the board agent decision, request for reconsideration, or the request for an injunctive relief. This concludes the Nimbus Consulting Group's tutorial on the state-mandated program for local government employee relations, also known as PERB. For more information on state-mandated cost-claiming services, please see our website at www.nimbusconsultinggroup.com or contact us at the number listed below.